If you saw posts today saying a new law just passed and that green card rules changed overnight, do not scroll past this. Not because I want to scare you, but because the most dangerous moment for immigrants is the moment right after a headline drops, when people act before they verify. In 2026, misinformation travels faster than the Federal Register. So here is what I'm going to do for you. I'm going to explain how to verify whether something truly became law, what the reported changes would mean if implemented, who would be impacted first, and the exact steps that keep you protected even in a shifting policy environment. Welcome back to US Policy Brief. I'm Fernando. My job is to cut through fear, rumors, and recycled screenshots. Today, I will break down what the new law changes, what it does not change, and how you protect your status step by step. This video is general information, not personal legal advice. If you have arrests, long travel, prior denials, or complex family facts, speak with a licensed attorney before acting right now. Before we talk details, understand one key difference. Headlines move instantly, but implementation usually takes months. A bill can pass, then agencies must publish guidance, build forms, and train staff. So do two things today. First, check official sources like USCIS, DHS, and the Federal Register for the exact language. Second, start preparing anyway, because preparation protects you whether timelines shift fast or slow. Most problems happen when people wait for certainty instead of planning. Here are the 7 points we will cover in plain language. 1. Faster employment-based processing and new premium options. 2. Stricter residence and travel verification. 3. A healthcare fast track with extra numbers. 4. A revived public charge style review. 5. A permanent pathway for dreamers. 6. A startup and entrepreneur channel. 7. New biometrics and a digital card system. Then I will give you a practical checklist for you to use today. First, employment-based green cards. The new law directs USCIS to move most employment-based adjustment cases through a streamlined track with a target of 180 days. The purpose is to reduce backlogs and keep skilled workers in the United States instead of trapping them in endless extensions. Funding is also authorized for hiring adjudicators, modernizing systems, and expanding digital filing. If implemented well, this could shorten real timelines, especially after I-140 approval today. The law also expands premium processing beyond the old limited list. For certain green card petitions and related applications, a paid option could produce a decision in roughly 30 to 45 days. That does not guarantee approval, but it does force a faster yes or no. For employers, it means planning is easier. For self-petitioners, it reduces months of uncertainty. If you can afford it, premium processing can be a strategy, not a requirement. Who benefits most from faster employment processing? People already in the United States in lawful status with a clear case file. H-1B, L-1, O-1, TN, E-visas, and many F-1 graduates. If you have an approved perm, or you are ready to file a national interest waiver, a faster I-140 decision plus a faster I-485 pipeline can reduce the number of times you must extend status. That is relief. What should you do now if you expect to benefit? Get your documentation ready before the rush. Employers should confirm job descriptions, wages, and support letters. NIW applicants should refine the endeavor description and collect independent evidence of impact. Everyone should gather identity documents, immigration history, and tax records because faster processing does not forgive missing pages. A streamlined system moves quickly, which means your mistakes also move quickly into a denial if you delay. Second, residence and travel compliance. The new law tightens how absences are evaluated for permanent residents. The old myth that returning once a year keeps you safe is not a rule. If you spend more than 180 days abroad in a 12-month period, expect enhanced screening on return. Officers will look for proof that the United States is your primary home, not a place you visit. That includes taxes, housing, work, and family ties. A reentry permit still helps for longer travel, but it is no longer treated as a magic pass. You can be questioned even with the permit if your overall lifestyle shows you live abroad. Carry evidence, lease or mortgage, pay stubs, employer letter, school records, health insurance, and a tax transcript. And never guess your travel days at the airport. The computer knows, and inconsistencies can become misrepresentation. Plan connections with time and stay calm. Some summaries also mention a yearly residence confirmation form. If that becomes part of the rollout, treat it like taxes: routine, required, and deadline driven. The real danger is missed notices. Update your address with USCIS using AR11 within 10 days of moving. Use USPS forwarding. Create a USCIS online account. A 5-minute task can prevent a months-long review triggered by silence. Set calendar reminders and save every notice as a file. Third, healthcare fast track. The law creates a priority green card pathway for certain medical workers: nurses, physicians, therapists, medical technologists, and home care aides. A separate visa set aside is intended to reduce competition and shorten waits. For many workers, the biggest benefit is reduced dependence on labor certification delays. The message is clear: the United States needs healthcare workers and wants them to stay. Qualify and prepare licenses, credentials, and proof. The law also adds protections against exploitation. Employers must follow wage rules, and some pathways allow portability so workers can change jobs without losing the green card process. That matters in hospitals and clinics where staffing shortages create pressure. If you are in healthcare, keep pay stubs, contracts, and licensing records. Do not rely on verbal promises. A faster pathway is only safe if your paperwork is complete and your employment is documented always. Fourth, public charge is strengthened again. This does not mean you can never use help, but it means USCIS may weigh long-term reliance on certain benefits more heavily. Many summaries mention a 12-month threshold within a 36-month window for specific programs. The key is your total financial picture: employment, savings, household support, and credible sponsorship. If you are applying soon, plan for stability and documentation. Do not guess. Ask guidance before filing. If you already have a green card, remember the rule is mainly about new applications, renewals, and discretionary reviews, not automatic punishment. The bigger danger is fraud. If someone claims benefits they are not eligible for or uses false information, that can create serious immigration consequences. If you received benefits during hardship, keep records and eligibility letters. If you are unsure, consult a professional before you file. Your goal is compliance, not fear, for family. Fifth, dreamers. The law creates a permanent pathway for people brought to the United States as children, replacing temporary protections with a green card route. Criteria typically include continuous residence, background checks, and education or service requirements. Processing is supposed to be prioritized, with a target timeline around 12 months once the system is running. If you are a dreamer, start gathering school records, tax records, and proof of residence now, and avoid any trouble. Some versions of this reform also expand family sponsorship options for dreamers once they become residents or citizens. That can be life-changing for parents and siblings who have waited for decades. But do not rush filings without advice, because family cases depend on lawful entry, inadmissibility rules, and timing. The best first step is documentation. Keep identity papers, DACA records if applicable, and a clean record. Preparation reduces risk when the application window opens. Sixth, entrepreneurs. The law introduces a startup green card path for founders who create jobs and attract investment. A common model is showing at least $250,000 in qualified funding and creating 5 full-time jobs, plus evidence that the business is real. This is significant because entrepreneurs were often forced into visa categories that did not fit. Now innovation becomes an immigration pathway if documentation is strong. Keep payroll records, contracts, and letters organized. The law also adjusts EB-5 investment rules, including reduced thresholds for rural or high unemployment areas and stronger anti-fraud measures. If you are considering EB-5, remember it leads to conditional residence first, then I-829 removal of conditions later. The good part is more accessible investment levels. The risk is sloppy projects. Verify regional center history, read offering documents, and keep proof of lawful source of funds. Missing documents can delay approval for years. Seventh, biometrics and digital cards. The law requires a biometric renewal process on a 10-year cycle, fingerprints, updated photo, and additional identity checks. This is framed as modernization to prevent fraud and identity theft. It does not cancel existing cards overnight, but it adds an appointment requirement when you renew. Missing the appointment can create trouble, so track your expiration date and schedule early. Some systems may include a secure digital version for verification. A digital green card component may also be introduced through a government app for work verification and identity confirmation. If that happens, protect your account like a bank account. Strong password, two-factor authentication, and no sharing logins. The convenience can be real, but scammers will imitate official messages. USCIS will not ask you to send your card by text. Verify links and use only official portals. When in doubt, check the USCIS site first. Now, what should you do in the next 30 days, regardless of politics and regardless of rumors? 1. Update your address with USCIS and save the confirmation. 2. Download your IRS tax transcripts and confirm you filed correctly each year. 3. Build a travel log and keep proof of ties like lease, job, and insurance. 4. If you plan citizenship, gather court records and review past filings for consistency. 5. Watch announcements before you file. Who needs to be cautious under any tightened system? People with long absences, people filing taxes incorrectly as non-residents, people with old arrests, and conditional residents with weak I-751 evidence. Also, anyone who relied on a spouse or employer and now has broken ties should plan before filing. Caution does not mean despair. It means you should prepare documents first, and if needed, get legal review before you trigger a spotlight on your case. Finally, let's separate fear from fact. No modern law should be read as instant mass cancellation. Most changes create procedures, not automatic loss. If you live in the United States, work here, file taxes, and respond to notices, you are usually safe. The people hurt are the ones who miss deadlines, ignore mail, or live abroad while claiming residence. Your best shield is consistency, documentation, and calm action, and you can start that protection today. If this breakdown helped you, subscribe to US Policy Brief for verified updates and practical steps. Like the video so more families see it before they act on rumors. Comment below with your situation, such as employment category, travel plans, or citizenship timing, and I will prioritize your questions in future episodes. I'm Fernando, and I'll keep monitoring official guidance as the law is implemented across 2026. Stay prepared, stay organized, and protect your progress. Let me expand on the address issue, because it is the most common reason good cases turn bad. USCIS and DHS send notices to the address of record. If you move departments or use a friend's address, file AR11 immediately and keep the confirmation number. Also, update every receipt in your online account. A lost letter can mean missed biometrics, missed interviews, and denial for abandonment. That denial is avoidable with one routine habit. Build a travel log now, even if you rarely travel. Use a simple spreadsheet with departure date, return date, destination, and purpose. Keep boarding passes or itinerary emails in a folder. If you ever apply for citizenship, those dates matter because USCIS asks for every trip and tests continuous residence. If you re-enter after a long absence, those dates matter because CBP compares your answers to their system. A travel log prevents accidental misstatements later. Imagine you run a business overseas and you fly back to the United States every few months for 1 week. Under older practice, many people did this for years. Under modern tracking, the pattern can look like you live abroad. If you spend more time outside than inside, you may be questioned about abandonment. The solution is not gaming the calendar. The solution is ties. Home, taxes, employment, and life centered in the United States. If you are worried about public charge, focus on documentation, not fear. Keep pay stubs, a job letter, bank statements, and proof of private insurance if you have it. If you used benefits, keep approval letters, dates, and the reason, because context matters. If a child received benefits, keep records showing the child's eligibility. Never sign forms with false answers. When a government asks about finances, records protect you far better than silence or avoidance. For dreamers and mixed status families, the most important job is evidence of continuous residence. That means school transcripts, lease history, medical records, and dated mail that shows you are physically here year after year. Keep copies in one folder and scan them to a secure drive. Also confirm your name is consistent across documents. Small mismatches create delays. If you qualify for a new pathway, file carefully, because the first wave will be crowded. If you are an entrepreneur interested in a startup pathway, remember, immigration will treat your business like a compliance file. Keep formation documents, cap tables, investor wire proofs, payroll records, and job descriptions. Track how many full-time employees you have and when they started. Do not inflate numbers. If your business fails, do not hide it. Update your plan. The fastest way to lose credibility is to submit optimistic claims without supporting evidence. Ever. Biometrics requirements sound technical, but the risk is simple. Missed appointments. USCIS sends a notice with a date, time, and location. If you miss it, your case can stall. If you ignore rescheduling rules, your application can be denied. So treat biometrics like court. Show up early, bring the notice, bring identification, and keep copies. If you cannot attend, reschedule quickly through official channels and save confirmations. Never pay anyone to change your biometric state. In every big policy moment, scammers appear. They offer paid registration, faster approvals, and secret forms that do not exist. A rule of thumb: if someone says you must pay today or lose status tomorrow, slow down. Real immigration notices come on letterhead and appear in your USCIS account. Official fees are published on uscis.gov. If you need help, use licensed attorneys or accredited nonprofits, not unverified agents on social media. Protect your identity always. If you already received a notice about travel, renewal, taxes, or benefits, do not ignore it. Read the deadline, make copies, and respond on time. If you do not understand the notice, do not guess. Ask for help. A late response can turn a simple clarification into a denial. A denial can lead to referrals or court. Most government letters have a path forward if you respond calmly and provide proof, even when policy shifts. One more technical point: effective dates matter. Some parts of a law start immediately, but many start 6 months later or after regulations are published. So do not assume you are late on day one. Track the announced phase and schedule, and respond when your notice arrives. If a new verification cycle begins, the first year often includes grace periods and support. Still, treat compliance as mandatory, because "I didn't know" is rarely a defense. Why does this law feel so big? Because it shifts permanent residence from passive to active. In the past, many obligations were reviewed only at citizenship or after long travel. Now the system wants continuous alignment between status and behavior. That change can feel uncomfortable, but it is manageable. People who live in the United States, pay taxes, keep an address, and respond to notices will adapt. People who ignore paperwork will feel pressure first. If you are planning to apply for citizenship in 2026 or 2027, treat this as your preparation year. Fix your taxes, confirm your travel totals, gather court dispositions, review your immigration timeline for consistency. If you had a prior marriage case, keep evidence that the marriage was real. If you had a prior employer case, keep records of the role and wages. Citizenship is worth it, but only when you can answer every question confidently. Let's recap the 7 takeaways. Faster employment processing and premium options may shorten waits. Stricter travel screening may follow long absences. Healthcare workers may get a fast track and extra numbers. Public charge review may weigh long benefit use more heavily. Dreamers may gain a real green card path. Entrepreneurs may gain a startup route and adjusted EB-5 rules. And biometrics plus digital systems may become routine. Preparation turns all of these into steps. If you want updates like this, subscribe to US Policy Brief and keep notifications on so you see verified changes, not rumors. Like the video if it helped, because it signals the algorithm to show it to other families who need information. Comment with your category and where you are in the process, and I will build follow-up videos around real questions using official sources and language. That is how we stay protected together. Remember, you earned your status through years of effort. A changing system does not erase that, but it can punish missed paperwork. So verify claims, read notices, keep your address updated, track travel, file taxes correctly, and document your ties to the United States. If you do those basics, most new compliance rules become routine, not threatening. I'm Fernando, this is US Policy Brief, and I'll be back with verified updates as details are released.